I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Welcome to Workplace Wake Up. I'm your host, Jen Shaw. Joining me today is employment attorney and my co-founder of EmployersLawyer, Joe Beachboard. Hi, Joe. How are you today?
I'm doing wonderful. Thank you for having me back to Workplace Wake Up.
Well, we're happy to have you here. So, Joe, we're going to talk today about arbitration. As you know, it's been part of the California employment law landscape for years, but the conversation is changing. For example, as we'll talk about in a minute, we actually got a new law signed last week by Governor Newsom here in California that's going to impact arbitration in some ways potentially significantly. And then there are, of course, a number of court decisions that come down all the time. I know you track these new cases, and not a day goes by when I don't see at least 4 or 5 court decisions even, or maybe every month, 4 or 5 court decisions about arbitration. I mean, this is something that is a very active area for the courts and the legislature, right?
Indeed, and I think this attention follows the fact that statistics tell us that more than half of all employers now have arbitration agreements with their employees as the means of resolving any employment-related disputes.
That's an interesting statistic, Joe. I didn't know that. So more than half. Okay. Well, here's the deal. We want to talk today about the advantages, the drawbacks of arbitration programs, and how you can really decide whether arbitration is right for your workplace. I think Joe and I both agree that there's no one-size-fits-all answer. Different workplaces have different needs and different cultures, different expectations. And so you really need to make a strategic decision when you're talking about arbitration. So, Joe, let's just start with sort of the basic question. Why is arbitration on our radar right now? Why are we even talking about this?
Well, again, I think it goes back to the utilization of arbitration. And as a result of that utilization, you're seeing more attention to it. It's become a bit of a policy debate in HR circles as to whether or not we should require employees to use arbitration. And then there's, like you mentioned, there's been a lot of cases, including a very high profile U.S. Supreme Court matter from just a few weeks ago involving the most popular sport in America, football, right? Involving the National Football League and an arbitration agreement that they had adopted. And there are many questions about, what's okay to include in your arbitration agreement and what makes it fair or what makes it unfair.
Well, and that's interesting what to include, because in California, of course, we have some extra complications. We got a U.S. Supreme Court case a couple of years back that made it sound like maybe we could require Private Attorney Generals Act cases to go to arbitration. And the California Supreme Court had a little bit of a different perspective on that. So now we have some complications where if somebody has a PAGA action, their individual PAGA case and the case they're bringing on behalf of their coworkers, right, what they call the representative action, may be brought in 2 different forums, right? One might be brought in court and one might be brought in arbitration. So that creates some complication. What is this new law that Governor Newsom just signed? This is something that I wasn't expecting. It certainly was a bill that I had read about, but I didn't know for sure that he was going to sign this. So what is that all about?
Yeah, it's very interesting, Jen, and it takes a little inside baseball really to even be able to think about what was the purpose of this new law. It doesn't take effect until January of next year, and I think there's some debate as to really how much does it change the circumstances. But basically what this law does is say that we're going to follow the federal law, which is, of course, the Federal Arbitration Act. We're going to follow the FAA in California with respect to what is enforceable and what is not enforceable. And I think that's specifically to deal with 2 issues. One, the exclusions under the Federal Arbitration Act for certain transportation workers. And then also, how does this federal law, the Ending Forced Arbitration Act, affect arbitration claims brought in California, because under federal law now, sexual harassment and sexual assault claims can no longer be required. We can no longer require the employee to resolve any of those claims through arbitration. And so this statute seems to be saying that in California, we're going to follow that law as well, which would exclude then a significant amount of possible claims that could be pursued in California from arbitration if the employee decides they don't want to resolve the dispute in that way.
When I heard about this new law, which is AB 2155, I thought it was such an interesting twist on what we usually see in California, because the legislature usually tries to say, hey, California law is going to apply here, and we don't want to be governed by what's going on federally, right? We don't want to be subject to whatever you're doing federally. In this case, it's the exact opposite. In this case, the legislature said, hey, we're going to embrace what's going on federally. We're going to look at these two exceptions to the Federal Arbitration Act, and we're going to declare by law that they apply here in California. So it's a 180, and I thought it was kind of an interesting trick, right? I mean, they really took a different approach and a different perspective. And I think one of the reasons why they did that is because we're talking about the Ending Forced Arbitration Act. That's a federal law. And a lot of folks in California are trying to use that law to get out of arbitration agreements that their employers have entered into with them. So the way they get out of it is by saying, I have a claim for sexual harassment, I have a claim for sexual assault. And there's been an open issue as to, okay, does that mean that the whole case gets taken out of arbitration? Does it mean that only those claims can be taken out of arbitration, and the rest of their case, if they have one, like wrongful termination or constructive discharge, as you and I have talked about before, whether those are going to be subject to arbitration or to a court proceeding? So I think when the legislature took this action, they said, okay, we're just going to clear that all up. We're just going to make sure that everybody knows that you're going to apply the federal law here, and those cases are not going to be subject to arbitration. Now, they haven't cleared everything all up because we still don't know what cases are going to end up in court and what cases are going to end up in arbitration. Joe, let's talk a little bit about this arbitration exception in the FAA for transportation workers, because I thought that was kind of an interesting category for them to focus on. Do you think that's because of all the litigation we've had in California with Uber drivers and some of them wanting to be independent contractors, some of them wanting to be employees, and AB5 and all of that? I mean, why are they focused on transportation?
Well, I think you have to start with the Federal Arbitration Act itself, of course, which is 100 years old. Mm-hmm. So at the time that law was passed, with that exception, there were certain unique issues associated with workers who were in the transportation arena. So if you look at it, it specifically references not only transportation workers, but folks like seamen, right? Which is not necessarily something that we think about a lot these particular days.
You're right.
But I think it was designed to, address concerns and issues in a prior era. And then, of course, there's been a lot of litigation, including several cases going to the U.S. Supreme Court on the question of who is a transportation worker and who is not. Does the truck you're driving actually have to cross interstate lines, or is it enough if just the goods do? And there was just, of course, a big U.S. Supreme Court decision this term addressing that issue and involving the company that makes Wonder Bread, right? So I really think California was trying to do was avoid preemption issues. I think that's what it comes down to. And that's a little bit, again, inside baseball stuff. But I think they really wanted to make sure that transportation workers are excluded, and they wanted to make sure that individuals who have claims for sexual harassment are able to decide whether they want to arbitrate or not.
Do you think this is maybe the first step in the legislature trying to ban all mandatory arbitration? I mean, they've done that in the past. We had Prop 51 that wasn't upheld, right? But do you think they're trying to think of a different way to do that, or is this really a separate issue?
I think it's a separate issue. I think that California has probably learned its lesson that it's not going to be able to ban arbitration agreements for employment disputes, absent there being something done at the federal level, which, there's measures pending. They're not going to go anywhere, but there are measures pending in Congress that would prohibit the use of arbitration to resolve employment disputes. But I think California learned that, look, we're going to get preempted if we try to do that. So that's why you're seeing this statute, right? This is kind of an end run around preemption. So I would not expect that there will be additional efforts to limit the use of arbitration agreement. I think if that's going to occur, you're going to see it mainly occur through the courts.
Got it. Well, and just so you all know, preemption, when Joe talks about preemption, he's talking about the fact that when you have a federal law that addresses an issue and a state law that tries to address the same issue, the federal law can often preempt, trump, if you will, what's going on in California or any other state. So in this case, the Federal Arbitration Act was Congress's intent to say, okay, the federal government is going to control how arbitration is enforced and how these agreements are prepared, and any rules that any other state has that are inconsistent with the Federal Arbitration Act are going to be subject to preemption. That's why Proposition 51 failed ultimately in the courts, because there was preemption, meaning that Prop 51 was inconsistent with the Federal Arbitration Act. Okay, enough law, Joe. Let's talk about what arbitration is, because as you mentioned earlier, more than half of workplaces actually are subject to arbitration agreements. And I don't know that everybody really understands what an arbitration program is. I mean, what I want you all to get is this is an agreement that you enter into with your employees. Both of you sign it. And it's an agreement that says, hey, we're not going to go to court. If we have a claim and our claim is something that is subject to arbitration, so certainly not a sexual harassment or sexual assault case, but something that is subject to arbitration, we agree that we're going to go through arbitration. And that means we're not going to go to court and we're not going to have a judge. We're going to have an arbitrator. We can do a little discovery. The arbitrator is going to issue a decision, but we're not going to have all these appeal rights and everything. We want to have a quick, relatively inexpensive way to resolve workplace disputes. That was the point of arbitration. And that's what I think the reason why a lot of employers have adopted these programs. And then, of course, as we talked about a moment ago, this whole issue with PAGA claims, we thought that maybe there was a way to ensure that all PAGA claims went through arbitration. That's not the case now. But if you write a proper arbitration agreement, you can get your class actions can be subject only to arbitration. So there are some strategic reasons why you'd want to have an arbitration agreement. What do you see, Joe, as the most important factors for an employer to consider when they are evaluating whether they should either continue with a current arbitration program or implement one that they haven't had before?
Well, there's a number of factors, and this is not a one-size-fits-all analysis, right? And so this is a discussion that you should have with counsel, and this is a decision that you should revisit regularly, because situations change, like this Ending Forced Arbitration Act, and that's changed the dynamic for many, many employers. But, risk tolerance is an issue too for consideration, right? I mean, in deciding which way that you want to go with this. But it's such an individualized decision now. You have to consider how your employees are going to react to the implementation of an arbitration system, how it may impact your ability to recruit employees can be impacted, and your utilization can be impacted. Like you're likely to see more claims if you have an arbitration agreement than if you don't. So these are all issues that I think that need to be considered and discussed with your counsel and with your leadership team.
That makes a lot of sense. You and I were talking in office hours the other day. At Employers Lawyer, we have 2 weekly office hour opportunities where our clients come and they can ask us any questions they want. We give them a presentation on a particular topic. We recently talked about arbitration, and it was very interesting to go through the pros and cons of arbitration, right? It used to be that it was always going to be less expensive and always going to be quicker than civil litigation. Well, now that so many people are arbitrating, and we have arbitrators who need to keep everybody happy, right? They can't be seen as management side arbitrators or employee side arbitrators. You get less decisive decisions sometimes in terms of a, quote, full win for the employer. People can charge, $20,000, $30,000, $40,000 a day to host an arbitration, to facilitate an arbitration. So these are, as Joe said, very big decisions for you to make internally and for you to really think about if you currently have an arbitration program, whether it's working for you, and if you don't, whether you want to implement one. One interesting issue is whether you can require folks to sign an arbitration agreement. And just remember, here in California, with the new employee, you can make it a term and condition of employment. With current employees, you may have to think about offering your employees something additional, a bonus of some sort to get them to sign an arbitration agreement. There's cases on both sides, and it looks like you actually can take the position if you're an at-will employer that continued employment is going to be enough to allow you to require arbitration. But then, as Joe said, you've got this employee relations issue of if somebody you really like, one of your favorite employees, doesn't want to sign that agreement, are you really going to let them go? Are you really going to take the position that arbitration is something that's going to be mandatory? And if they don't agree to it, you're not going to let them stay employed. Well, Joe, we're getting to the end of our time. Is there anything else that you'd like our listeners to think about with respect to arbitration, or any sort of last minute advice you want to give?
Well, what I would say is enter into those kinds of relationship and agreements with care, right? There's a lot of rakes out there that you can step on, a lot of mistakes that can be made, especially if you're using outdated agreements or you aren't considering the fact that now it appears sexual harassment claims will be excluded from arbitration, or at least the employee will have the right to exclude it from arbitration. And so there are these constant changes and developments. It's a very dynamic area of the law. As you mentioned, Jen, we're seeing case rulings all the time saying what's a fair system, what's not a fair system. And I do think that, employers need to consider whether or not this makes sense to them now. Jen, I know you and I were talking about this, and earlier in my career, I pretty much said I think arbitration is in California, where the risks are so high from being in front of a jury, that arbitration is pretty much a requirement for employers to pursue. And I don't really feel that way now. I still think that it's a good system. I actually believe it's a better system for employees than it is for employers, which is strange because I end up arguing on behalf of employers all the time and defending these systems with people who say that these are not favorable to employees. And I don't really think that's true. I think employees benefit as much or more than employers do from the advantages of arbitration. But having said all of that, I think you have to be very careful if you pursue this. You have to think about your employee relations issues, and you have to think about how you're going to communicate your arbitration program to your employees. And those are all critical issues that you just need advice and help with as you're deciding whether to adopt or whether to continue an arbitration.
Joe, those are such great points. And I do want to encourage all of you, if you're looking at your arbitration program, whether to adopt one or whether to continue it, as Joe just said, you do want to bring in your counsel, you want to bring in your leadership, you really want to make this a strategic decision. So before we wrap up, everyone, if you enjoyed today's discussion, be sure to follow Employers Lawyer on LinkedIn. That's where you're going to find Week at Work. Week at Work is Joe's weekly video law update, where he provides very hot off the presses court decisions, regulations, rules, crazy, bizarre cases that have been filed, and also practical tips and information. So you definitely do not want to miss Week at Work. It is available on LinkedIn. So as I said, please follow us on LinkedIn, and you can always go to EmployersLawyer.com to learn more about Employers Lawyer. Joe, thank you so much for joining me here today.
Always a pleasure, Jen. Thank you.
And thank you all for listening to Workplace Wake Up. I'm Jen Shaw, and I'll see you next time. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.